when you don't know what's going on in the court, it's really hard to have any faith or trust in the system.
Hello, I'm Lisa Szyc here with attorney Michancy Cramer and the Honorable Erika Mendoza, and we are here to introduce you to Erika off the bench. You are from Rochester, New York, and I imagine that is a big change from there to desert living. What's it been like living here, going to UNLV? Tell us a little bit about your background.
So yes, I'm from Rochester, New York, which is upstate. It's kind of in between Buffalo and Syracuse. And I absolutely love it there. However, I absolutely had enough with the cold. So when I graduated college, I knew that I just wanted to get out of the cold and I was going to go somewhere warm, but didn't have a very specific plan. Happened to have a tangential friend of a friend who was out here and was opening a place up, and it sounded like, okay, yeah, that sounds good. Vegas is warm, sounds like fun. And so I made the trek and I came out here. At the time, I thought that maybe eventually I wanted to go to law school, but wasn't going to go right away. So I worked in the hospitality industry, which is what I had done since I was 15, especially important here because it's really the heartbeat of our community. So I did serving and bartending work for a couple of years until I knew for sure that this is where I wanted to stay. And then I went to Boyd. And after that, I moved on to the DA's office. But transitioning to Las Vegas, it's been almost 20 years at this point. So I think that I count as a local by now.
Does it feel like home?
Yes, okay. Now it does. My husband is born and raised here, and we have 2 kids. So this is definitely home. I love the excitement of Las Vegas. I still, a lot of people don't like to head down to the Strip too much, but I still like to take advantage of the restaurants and things like that we have to offer. And I love how much we've grown up over the past almost 20 years now.
Because you've gotten to see the city change.
Yes.
Yeah.
Yes.
So you mentioned Boyd and the DA's office. I noticed on your website that you kind of knew from the beginning that you always wanted to be a district attorney. Mm-hmm. Tell me a little bit about that.
Yeah, so I thought when I was planning on going to law school that I probably would be a prosecutor. That's what I planned to do. And then in law school, I had kind of a unique experience that told me for sure that was absolutely the right thing, which was my dad was actually killed in a car accident.
I'm sorry to hear that.
Thank you. And it was it wasn't a DUI, but a reckless driving type situation. Not here, another state. And it went through a criminal trial. So from day one, arrest all through criminal trial. We were involved in that process with the police and all different levels at the district attorney's office. It was in Texas. We were there for every day of the trial, and ultimately he was convicted, but there was an appellate issue, and it got overturned. So it was a long, long, long road. And what was especially compelling to me was we had these 2 families, not just my family, but this other guy's family, who were completely devastated and ruined by this event. And the care with which all of these people handled us and how much they communicated with us, even on bad days, and took our opinions into account and were really respectful of us, was really amazing to watch and experience, because we were going through some of the absolute worst days of our lives, and these people were able to make it a little bit less terrible just by treating us with care and respect. And even when the ultimate outcome was so emotional to have it changed on appeal and stuff, just the care with which they handled it was really impressive to me. And I knew for sure that this was the path I wanted to continue, because even when I couldn't, as a DA, even when I couldn't handle a case exactly the way that a victim wanted it handled, to be the one to be there and help them through something that's so difficult and handle them in a way that makes it a little bit easier for them is very rewarding.
Would you say that experience influenced your ability and your role as a prosecutor?
Yes, absolutely. But because I knew how it felt to be not only somebody in the necessarily specific to the victim's role, but somebody who wasn't familiar with the system. As a lawyer, it's also second nature to us. And when we're dealing with people who aren't in the system, sometimes we talk about things without realizing how much we really need to explain them and stuff. And so to know what it felt like as somebody on the outside really allowed me, this is obviously before I was really familiar with the legal system, because I was still just in law school at the time. But that allowed me to much more easily be able to talk to them about the legal proceedings and things like that in a way that would help them understand things that seem really, really frustrating on the outside when you don't really understand it.
What has it been like going through the process of being appointed by the governor to get to where you're at now?
So the process is actually, it's funny because when I first started on this process, some people have kind of the idea that being appointed is an easier route. And to me, it's definitely more arduous. The application you have to fill out for the appointment is more extensive than the bar, really. And then you have to go through the selection committee interview, which is, I think, 9 community leaders on the selection committee that you go and do a big live interview in front of them. They do that with everyone who applies, and then they narrow it down to 3, and the 3 are sent up to the governor, and then the governor ultimately makes the decision. So that process alone was very intense, and then to have to immediately thereafter roll into an election certainly isn't what I think is the easier route. But along the way, I've really enjoyed getting to know a lot of people that I've gotten to know along the way. It's one kind of surprising thing in a good way is, you all know, a lot of times being in court all day, people don't generally go to court because something great's going on in their life.
Right.
So when we're in court all day, we're generally tending to not see the best of people, and it can really bring you down sometimes about, the state of the world, because that's what we're seeing all day, every day. But being out and about so much and getting to know so many people, I'm really getting to see the complete opposite side of the community, really all of the people who care the most and are most interested in making sure that this community is growing in a positive direction. So I've really enjoyed getting to know everyone along the way.
My history is not in criminal practice at all, and so I have no experience. But Lisa and I are actually longtime friends. We've been friends for several years now, and the way we became friends, she actually tells the story. It's very funny the way she tells it. But we started out as on the opposite side, and we were in family court, and we. I'll just say that after our first hearing, when Lisa first met me, she was not my number one fan.
Not at all.
And so luck being luck, the very next week we get another case together. And so then she picks up the phone and says, let's go to coffee. And it was family court, there's kids involved, limited resources. They certainly don't need to burn through, the family's resources in court. And so ultimately we did resolve both the cases in settlement. And we've been friends ever since. And so just when we were talking and preparing for today, one of the things I wanted to ask you was, as a district attorney, you represent the state and you are prosecuting people accused of crimes. But on the other side, there's another attorney who plays a role in our judicial system, and that is the criminal defense attorney. And you can either have like the public defender's appointed counsel, or you can have private counsel. And as a DA, what could you say you learned, and what do you take away from your interactions with defense attorneys over the years?
So, obviously both sides play such an important, crucial role in the system and making sure that the system as a whole is working in the right way and everyone's rights are protected. What I will say is, I think it's probably common in all areas of law, so you guys have probably seen it too, is when you're younger, you're just so excited to be out there, and you tend to get, you're not as good at necessarily picking your battles, but
That's fair.
you want, there's more battles to be had. And then over the years, you know, everybody kind of finds their groove and, you know, gets to a point where, you know, if you've been doing it for long enough and the other person on the other side has been doing it for long enough, you can cut through the, you know, the muck and kind of figure out, okay, this is what we're really talking about. You know, we've got these two issues on this big case that we know this is what it's going to come down to. I know this is the way you see it. I know this is the way I see it, but can we meet in the middle? And I think when you get two people who have been doing it for long enough that they can see the issues, it can be very easy to work with the other side because most of us have been doing it for long enough. And once you get to that point, it's just so much more of a pleasurable experience. I think that that's kind of what tends to cause most of us to mellow after a little while, because after a while you just realize, well, it's not fun to live my life where I'm arguing all day, every day.
Every case is a
both
battle.
sides play a role. You know, we can be cordial and still do our jobs and not have to decide we really dislike each other and have a stressful day in the interim. So
I have routinely said that the criminal bar is probably the easiest to reach across.
Yeah.
I especially doing criminal and family, I more often reach across the criminal bar.
Yeah.
Yeah. So. Yeah.
Yeah.
So as a judge with a background in prosecution, how does the defense bar inform your judicial philosophy, or does it?
Mm-hmm. Well, I'm always considering, you know, both sides. I think one thing that's unique about moving from a prosecutor to the bench is when you're a prosecutor, you don't have one client. Your client is the community. So in most types of lawyering, you have one person who you're looking out for this person's interests. As opposed to a prosecutor, you're constantly having to make decisions that are taking into account all different people to figure out. Your ultimate goal isn't, you know, to necessarily convict someone of a bunch of crimes or send them to prison forever. Your ultimate goal is to analyze each case individually and figure out, well, what does justice mean here? And so a lot of times you have to, you know, this kind of ties in with me talking about having to have difficult conversations with victims and stuff. A lot of times when you decide what justice requires in an individual case, someone's not going to be happy about it. And you have to have a conversation with a detective who wants something else, or you have to have a conversation with a victim who wants something else, or, you know, a lot of times you're having a conversation with a defense attorney who wants something else. And very quickly you learn, especially at our DA's office, there's a lot of discretion and autonomy there that really, I think, helps them flourish. But that leads you to very quickly be comfortable making difficult decisions and owning them and defending them, because somebody's going to be mad and you have to own up to it. You can't avoid it and you can't go back on your decision. So that kind of allows for a unique transition to the bench, because you know, sometimes when people try and make the transition to the bench, they aren't comfortable actually making the decision, pulling the trigger. It's an uncomfortable position for them. But that's something that I've been doing all along, as far as like taking into account specifically the defense point of view. I'm always listening to both sides, of course. Whenever any individual person comes in front of me, I'm always trying to analyze this case in front of me first, like the underlying event, and then the person, what's unique about them, to try and figure out what's the best solution. And I should clarify, that's when there's a discretionary decision to be made. Mm-hmm. When the law mandates a certain decision, I'm following the law, because that's, you know, my job. But if there's a discretionary decision to be made about what's best for the community, I'm always trying to analyze the individual and the crime to figure out what's the best solution long term. Well, does this person, you know, need to go away for a while for a deterrent factor and make sure that they can't hurt anybody else? Or is there something going on that can be addressed in a way that won't threaten the safety of the community, and we can get them in some kind of programming to fix the problem? So that's kind of the way I take into account the defense side of things.
So kind of a hot topic in the Vegas legal community for the last few years has been that of civility. Mm-hmm. And especially when I was in court more, I'm not in court quite as much as I used to be, but I used to tell judges, Your Honor, you're seeing this side of it, but you don't see what goes on in the background, out of court. And judges specifically don't see that.
Yeah.
And they're not supposed to. They're supposed to be the neutral. And so one of my pet peeves was attorneys who would behave egregiously out of court. And, making misrepresentations to opposing counsel. Sometimes you might have an agreement on a procedural matter, and you feel like, well, this is my colleague, I trust them, we have a deal, we're going to proceed this way, and it's not going to impact anybody's rights. It's not a matter of representation. It's just like a little procedural matter or whatever. And then they go to court and say something else. Or they tell you something in email, and then they say, oh no, I never said that. Or they could, I've even had an attorney yell at me one time and cuss at me on the phone. And then they go to court and act very proper. And I would always tell the judge, this is the side you're seeing. You're not seeing the side I saw out of court. And so I always felt like when you go to court after you've put up with this bad behavior, and then you come to court and you're a little bit steamed. You might be a little bit mad. You might speak a little abruptly. And then you get accused, oh, well,
you
not
speak abruptly? Never.
I know. Shocking. But then, there's this call, oh, well, they're not being civil. And I feel like, no, civility goes beyond just the courtroom. And that's my personal philosophy. It's not just what you present. It's not using your pretty words while you're standing in front of a judge. Yeah. And so given that it's been such a hot topic, I kind of wanted to hear what you, as a judicial candidate, what's your philosophy on civility and those kinds of arguments in court and that kind of thing?
Obviously, that's a wonderful goal. We should all be striving for civility with one another. And I think usually that kind of ties into what I was saying before, that when you're newer, you tend to get riled up about more things than as time goes on and everybody kind of mellows. I think everybody usually learns that it's not, no individual case is worth, your reputation is worth, having any kind of ethical violation or anything. Long term, while you always need to be doing your best to represent your client's interests, there's no reason that in doing so you have to be nasty or be mean to anybody or hide any material information or anything like that. I don't think there's any reason to do it. That said, of course, we've all experienced it. And I think over time, you just learn as an attorney how to, when you're experiencing outside of the courtroom, you just learn how to guard, act on defense, like, okay, this person we're not going to talk about on the phone anymore. We're just going to talk via email because that's less likely to lead to heightened emotions and everything's on the record. And as far as it spilling over into the courtroom, I understand. I think that's one thing that I usually try and point out is the importance of having somebody on the bench who has real courtroom experience as opposed to out of the courtroom. There's a lot of important legal jobs that don't put you in the courtroom as much. But I think to be a really good judge, you need to have that courtroom experience. And this is a good example of where it's important in that being somebody who spent a lot of time in court, I understand that it can be an emotionally heightened place, and I can it'll easily roll off my back if somebody gets excited in court. Of course, I encourage them to tone it down, and everybody I reinforce the expectation of behavior, but at the same time, if they step outside and compose themselves, they're more than welcome to come back in and we'll move on. I'm not going to hold it against them forever. So obviously civility is an ideal thing that we should all be striving to. And when you are encountering someone who's not acting in that manner, you just need to not act in response as best you can and learn your defensive mechanisms to deal with it.
I want to just jump in real quick and ask you a question because you made it a point to highlight it, so I think you might want to talk about it a little bit. Take a minute and kind of highlight what your courtroom experience was before you got on the bench.
Yeah, so as one thing that's also unique about being really in most criminal positions, but particularly at the DA's office or the PD's office, is you're in court almost every day of your career from day one. We were in court doing arraignments, preliminary hearings, grand jury presentations, sentencings, trials, motion arguments, probation revocations, almost every day in court. And what's I think particularly unique to criminal is, it's you kind of see, I see both sides.
Yes.
Where in criminal, you can go in and plan on arguing one motion, and all of a sudden we've taken 3 turns and we've talked about 4 different legal issues, and all kinds of side peripheral things come up, and you have to be able to adjust and think on your feet very quickly. So it's really important for the judge to be able to do that, and without the both the courtroom experience and the criminal specifically experience, it's really difficult to do that. Civil is different in that it's very the subject matter is difficult, but there's more rules, there's more law. So as long as you're willing to put the time in to work hard and learn and research, you can usually find the answer. It's not as intuitive and requiring quick thinking as much as criminal. If I just were to talk about numbers, I mean, I've handled thousands of cases since I started at the DA's office. The last several years that I was there, I was specifically on the gun crimes unit, where I had while I was there, probably I tried to estimate maybe like 350 cases over the past several years, and those cases are all complex felony gun crimes, so which would generally mean multiple defendants, multiple events. So a typical one would be maybe a robbery series where 3 guys hit a bunch of convenience stores over a couple weeks. So one case is really like 15.
A series of cases.
Yeah. So, and having that real complex caseload, I think aids in the transition both to the bench and to civil, learning the civil, because it requires just a really heightened level of organization and attention to detail.
I was just going to use that phrase, attention to detail. So do you think that your courtroom experience that you just described has equipped you to handle pro se litigants?
As much as anybody is equipped to handle them. So one thing that I will say is a lot of people ask me a lot of questions about my restaurant and bartending experience. And one thing that actually, who would have known at the time, but when you're doing that, you're learning how to talk to everybody that comes in and sits at your tables, or everybody that sits at your bar. You better learn how to talk to them and relate to them. And so that really helps in terms of, whether you're talking to a jury panel or individual people in front of you, having that experience of having to figure out how to talk to anyone is helpful. Also, over the past several years, I think really they started in COVID in criminal doing criminal settlement conferences where...
Yeah, that is a relatively new concept.
Yeah. And so we would go in there, and a lot of times the way it would kind of work is the judge, so the party, both attorneys are there, the defendant's there, and a judge, not the judge who's presiding over the case, but a neutral judge will come in with the parties, and we'll talk about the evidence and what we think it's worth in terms of the negotiation. We try to mediate a middle ground. But the way that often starts is by the presiding judge saying, "Oh, state, why don't you tell so-and-so about what you expect to present at trial?" And throughout the afternoon or whatever you have, it's really the most significant time where the DA will a lot of times sit down with the guy and be like, "Hey," and really just try and talk to them one-on-one. And usually the attorneys are there, of course, but they are comfortable with the conversations, and you can really just talk to them as a person about, they tell you their side of things, and you can explain, well, I see what you're saying, but here's what my evidence shows, and this is why I'm where I'm at. I understand why you're concerned. And learning how to talk to them in that environment is, since we started doing that, I think has been really helpful to transitioning. As far as the pro se litigants, I think a lot of times if you just take the time to listen, and sometimes people just want to be heard. So I try and just let everyone, make their record, and then ultimately it can be tricky with the pro se ones because we can't give legal advice. But I always try and direct them to the resources that we have down at the Self-Help Center or the Legal Aid Center of Southern Nevada.
Do you find that it's a struggle with the pro se litigants in courtroom control?
Mm-hmm. Well, like I kind of, when we talked about civility, generally I try and start out by just listening and being calm and patient. And usually as long as you listen and you talk to them nicely about their concerns, usually it's okay. When things start to escalate, if it gets to the point where they're being disruptive or disrespectful to a point where it's offensive to the courtroom or it's disrupting things, then we will have them step out. But like I said, I don't, hold it against attorneys when they get riled up. If you go out in the hallway and you compose yourself, you come on back in and we'll continue dealing with your issue. I'm not going to hold it against you in the future. So I haven't had anyone who those approaches don't help with.
Okay.
Yeah.
It's a very mom approach. I like it.
I was gonna say maybe my mom experience is
everybody had takes some time out.
Intertwined. Yeah.
Yeah. Okay, and do you have an opinion? And this is specifically just like targeting your years as a prosecutor.
Mm-hmm.
Do you have an opinion one way or the other on an individual's right to represent themselves?
Well, my opinion.
Yes.
Of course, as a judge, you're entitled under the Constitution. You can do it. So of course I wouldn't interfere with that. Part of I'm sure you've been there when they do what we call Feretta canvases,
Yes.
where basically when somebody indicates they want to represent themselves, you have to go through a questioning with them to make sure they understand what that will entail. And part of that questioning usually is, even lawyers who have legal training and experience usually choose not to represent themselves because it tends not to
not a good idea.
Not to work out. Aside from the fact that if you're not legally trained, the emotional investment and attachment you have to the matter causes you a lot of times to be able to proceed in a way that's beneficial. But if somebody wants to do it, that's their right. And as long as they are, not disrupting the courtroom, then they can do it. That is another example, though, as a DA of how I learned how to really talk with them. Is I actually tried one murder trial where the defendant represented himself all throughout trial. And then I had another murder trial where for several years leading up to trial, he was representing himself. And you have to treat him like a colleague at that point,
Right.
So it was always a unique situation to be in the courtroom with your defendant, who you're also treating as your your opposing counsel, and have to, show them the exhibits that you're going to admit and stuff. But it's just you treat it like a job and you use your civility in it. But that's another way that I, learned how to talk to all different kinds of people.
So something that's brought Nevada into the international spotlight very recently, is media coverage of courtrooms.
Mm-hmm.
And we specifically have a family, very well known, the Murdochs, doing some trust litigation in one of the northern counties. And so there's that. There's some controversy right now with the media coverage of that.
Mm-hmm.
And so being that we are here on our Nevada Judges, I wanted to kind of get your philosophy and hear what your thoughts are on media in the courtroom.
Mm-hmm. So, of course, the default is it's a public place. People have an interest in seeing what's happening in the community. And so I think the default would normally be that the proceedings are open to the public and anybody can come watch. Now, that said, there are exceptions, and to the extent someone comes to me and has a legal exception to that general default, I will of course always follow the law. There are some situations where there's restrictions if there's a really young person involved, or where there's concern for a witness's safety or something like that. And I think as long as those exceptions are unique, are carved out for very specific policy reasons, like a witness's safety or something, and that as long as the law is being followed carefully in those situations, I think that those reasonable restrictions are overall, have been determined to be in furtherance of a policy that the community finds important, and I'll always follow those rules.
But generally, no.
The default is it's a public place.
Love that.
Yeah. I don't think we haven't had any times where we've had to close it so far. Once a trial starts or something, you have to exclude anyone else who's going to be a potential witness. But we have people come in and out who are just observers who watch the general calendar and throughout trials and things like that too. I actually think, the public has a lot of times one idea of what happens in the court system and the criminal justice system that isn't always the same as reality. And so I always try and say, everybody's welcome to come in and just watch and see,
what happens in a criminal courtroom is definitely not what you see on Law and Order sometimes the struggle of making real life people understand that is difficult for practitioners. So I love the idea that you're willing to open your courtroom and let John Q. Public see, hey, this is what happens in actual courtrooms.
I think especially to increase public confidence in the system as a whole, the transparency, the default of transparency is important.
I agree with that. I think it's very valuable. When you don't know what's going on in the court, it's really hard to have any faith or trust in the system. And, as we know, our courts cover a lot of areas of people's lives. It's not just criminal court. You could have a car accident, be involved in a civil suit. You could be in a business that gets involved in some kind of business lit. You could find out that your spouse has been gambling tens of thousands, hundreds of thousands of dollars on credit cards, end up in family court. There's so many things people don't know that they could land in court very quickly. And
when you don't know something, it's even scarier than it actually is. You have no idea where to sit, how the courtroom's going to be positioned. Sometimes that is scarier than actually walking into the courtroom.
Yeah.
And that's one reason why I've been a big supporter of our Nevada judges early on, and what they do is educating the public about that. So when you do end up in a situation where you're suddenly dragged into court, you have some more confidence in the system. And it's not even so much knowing, the legal part, but having confidence that, okay, I know this judge is going to hear what I have to say, even if I don't have all the pretty words like the lawyers do, all the Latin and whatnot. I know I can go up there and I can be heard, and this person up there on the bench is going to listen. And I think that's very, very important to the community.
I've been surprised as I've been out and about over the past couple months. Obviously, people have a really hard time figuring out and deciding elections who to vote for judge, because unless you're in court all the time, unless you're an attorney who sees how this works, it's really hard to figure out, it's hard to figure out who would make the best judge when you don't even really know, what does make a good judge to begin with?
Right.
And to the extent in elections, people sometimes tend to follow, a certain set of ideals as far as party lines go. The judges are obviously nonpartisan, so there's no
That's
direction.
not even a direction.
Yeah. So there's already that, baseline frustration in terms of figuring out judges. But I hear a lot of people say, I'm never going to be in court. That doesn't really...
It doesn't affect me.
It's not going to affect... But like you're saying, there's so many ways. Or jury service. Everybody, or even just a traffic ticket, anybody could end up in there.
You never know. my past, I used to practice a lot in family court, primarily for many years. And that was one thing. I had so many people, they were just like, I had no idea.
Yeah.
And I had so many clients that were just like, I had no idea it was like this. I'm like, you got to pay attention. You got to know these things.
Of course, we all hope we never have to go there.
Right?
Yes.
Yeah.
But like you said it earlier, like when people are walking to the court, it's almost never for a good thing. Like
Yeah.
it's like with the exception of adoptions, it's
Yes.
usually like the worst day of your life. Like
Yeah.
so. You mentioned something earlier about learning in preparation for your civil calendar. We've talked a lot about your criminal experience. In the last 4 months, what has it been like having to take on a civil docket?
So right from when I started the appointment process, I kind of started prepping for this because it's a big undertaking. Obviously, I don't deny that. What I started to do when I first started the appointment process was I would just go sit and watch other judges' civil calendars, and I would kind of take note of the different things that are on calendar that day. I would research them before I even went in there to try and figure out, okay, what do I think is likely to happen in this type of proceeding? Where do I think this is going? And as I would watch, I would take notes about it, and then most of the judges were very helpful and were willing to talk to me afterwards about procedural issues that surprised me and explained, oh, well, that's how this worked out, not the actual subject matter or anything, but just procedural stuff. So I intentionally did that in multiple different courtrooms because every judge has their own unique style. So I did that in several courtrooms. I watched almost all of the whole civil trial before I even took the bench, and then I also just consulted with a lot of the judges who mainly had civil experience about what do you think is important and all of that. So I did that before I took the bench. And then since I've taken the bench, I go out of my way to always ask when I meet civil attorneys about what's important to you, what do you think that people coming from the criminal world might not understand. And one of the most important things that I always hear is, can you just make sure that you're really prepared and make a decision? And so so you would think that this was a standard, but I always work really hard to just, every case that's in front of me, I go back to the very beginning of the case, to the complaint, and read from day one. So I understand the procedural history, not just the issue that's in front of me right now, but how we got here. And then for the issue that's in front of me that day, I always make sure, obviously, to read the parties' briefings really thoroughly, and then I research the law that they've cited to make sure that I understand kind of the background of the law and make sure they're citing it appropriately. And then if I come across any sometimes I'll come across a case that's connected that nobody mentioned, and so I'll be able to follow up with them and say, oh, this other case is similar, did you guys see that? Or I'll notice kind of like a hole in terms of the law or the facts in their motion work, and so I'm able to make notes before I go in there about I need to follow up with them on these issues. And the attorneys have been...
So you're very Socratic with the attorneys that appear in front of you.
There's been another thing that I always hear that I've been working really hard to do is, can you, especially in civil, some days you go in there and one case they'll have 5 motions on, and if you just say, okay, I'm ready for you, I mean, they could talk for 5 days. They don't know if the judge has read. They don't know. So I always try and tell them, okay, we're here for this thing. I read, I did my research. Here are the specific points that are standing out to me that I want clarification on. Can you tell me a little bit more about this? Of course, if you have, I'll let you be heard. And if you have more to tell me, I'll listen. But these are the main things that are standing out to me. So I've been doing that. Like I said, just the importance of being willing to make the call is really important. A lot of people have told me, even if you're not ruling my way, just make the decision.
Absolutely.
Punting or delaying doesn't help anybody. Just
waiting 6 months for an order does not make us happy.
And it allows the attorneys to much better value their case, and it leads to just better consistency, predictability. You can resolve and move your cases much more quickly if you can say, well, I know Judge Mendoza she does this typically in these situations. So it would be, here's where the value of our case is, as opposed to somebody who has a hard time making the decisions. The consistency and predictability is often what the attorneys say they want more than just somebody who's going to rule in their favor all the time. So
No, I can say that for sure. There's been times both in family court and in civil practice where I walk out and I'm like, I have no idea what the judge just ruled.
Yeah, we've all had those days.
And then there's days where you're like, okay, I know I'm going to wait at least 6 months before I get a decision.
Yeah.
Well, and sometimes there are certain things that are prompted by the entry of that written order. And so even if you do get an order and it doesn't get signed for 6 months, it's like, okay, you're, not only are you holding up the case, because obviously we don't want dockets that are, 10 years old, but also these are people's lives sometimes, we've got all kinds of things going through the courts. And so getting that decision, not only making the decision, which I know you've mentioned it several times and I'm sitting there, yes.
Please
Just make the decision.
Yeah, good or bad, just make it.
And but then also getting that order out, getting in writing, getting the entry filed, and it is really helpful. And you're right, it does help move the case along.
Yeah.
Are you willing to call in the attorneys that don't submit the orders?
Well,
that's another problem.
I was going to say, in connection to the civil, adjusting to the civil, I was, I've been pleasantly surprised that all of the civil attorneys have been super supportive in terms of the election and campaign and stuff. So I feel like things are going in the right direction. I feel like they've been happy so far. The orders, being on the backside of that is very interesting because a lot of sometimes I work really hard to make a thoughtful ruling, and then when the order doesn't come, by the time it does come, it's like,
wait,
oh
what did
shoot,
I rule?
and now I have to go back and basically start all over again. And then if the parties don't agree on what was said, then I have two different orders. So that goes back to one of the reasons why I work really hard to be very thoughtful and clear in what I'm doing every day, because I know the last thing I ever want to do is create more work for myself down the line. So I try really hard to be very thoughtful and clear in making decisions. That way, hopefully I'm not getting two different orders that I just have to rework and watch the video and read the transcript in order to figure out what happened. So
that's fair. Well, thank you so much. Is there anything that you want to tell the Las Vegas community in preparation for the upcoming election?
So if you'd like to see more about what I'm doing, you can go to judgeerikamendoza.com. Also, it's District Court Department 27. It's half criminal and half civil. So we do all types of cases in those arenas, no family. But my number one priority is always just going to be follow the law, even where very important for a judge, even if you don't even if it's not a law you personally think would make or would promote. Our job is to follow it. If I wanted to be a policymaker, I'd go to the legislature. But if judges start, trying to make policy decisions and legislating from the bench, the whole thing falls apart. So number one, always following the law. To the extent I have discretion, I always work really hard to take individuals' unique situations into account and figuring out what's best for the community and public safety as a whole. Like I said, I think one thing that kind of stands out as far as my background is going through the appointment process. Just really, I've already been vetted. It provides an additional level of assurance that I can do this and I have the right background for it. The criminal experience is incredibly important because making those on-the-fly decisions that can really affect either a criminal defendant's rest of their life or the whole community's public safety is really, really important. And ultimately, as far as it relates in terms of the civil and the bench as a whole, I always acknowledge that, most of us are never going to be you're not always going to be the smartest person in the room or the more experienced person in the room, but I will work harder than anybody. So as far as any kind of unfamiliar areas, there are for me. I'm always willing to really work hard to produce a positive result for everyone, and I will always make a decision to avoid delay and encourage consistency and predictability.
Perfect. Thank you so much. Again, Attorney Lisa Szyc, Attorney Michancy Cramer. We're here with Judge Erika Mendoza. And before we sign off, Judge, why don't you tell everybody where they can reach you and how they can find you?
JudgeErikaMendoza.com is the best starting point. Right on there, or on the website, is further is all the social media and mailing address and phone number, and the email is Erika@JudgeErikaMendoza.com.
Thank you so much.